Appeal Number 65, the people of the state of New York versus Lawrence Frumusa. Counsel?
Good afternoon. 3 minutes for rebuttal, if I may.
3, sir?
3 minutes.
Yes.
The county court erred as a matter of law in this case by admitting a civil contempt order, which, in the context of this case, revealed a Supreme Court justice's finding that Mr. Frumusa committed the very larceny.
Well, he put his state of mind in play, didn't he, now?
He did. That was a critical issue in this case. But our position is that the prejudice in this case as to that question substantially outweighed any probative worth. In fact, as the people seemingly concede, the contempt order was immensely prejudicial. It came dangerously close to directing a verdict against Mr. Frumusa and usurping the jury's fact-finding function. Yet it really had no real probative worth.
Well, it's what if we start out with the premise that this isn't Molineux? Let's accept your premise that it isn't Molineux. It's not a prior bad act, so it's not being introduced as propensity evidence, but it seems to be clearly relevant. It involves the acts that are involved here. Would you agree to that?
No, I wouldn't agree to that. First of all,
Okay,
I
go
agree
ahead.
with you. Well, I agree with the first part of the premise.
Oh, sure.
It's not Molineux. In matter of fact, it's far more prejudicial than Molineux evidence.
Well, no, that's the second part of the Molineux analysis. First is the propensity evidence, and then we measure prejudicial or probative value versus prejudicial effect. But you measure that as to all relevant evidence. So if we assume it's relevant evidence, and you say no, it's not relevant evidence, then it's really just a question of the balancing between probative value versus prejudicial effect.
All right. If we do the balancing, the people contend that its probative worth lies on the question of knowledge and mistake of fact. There are 4 reasons why it's not sufficiently probative for that question.
Go ahead.
First of all, knowledge and mistake of fact really weren't at issue in this case. It was not Mr. Frumusa's contention that he mistakenly believed the money belonged to him. It clearly didn't. It belonged to WHD, the company. It's obviously an unlawful taking to take the money. Rather, it was Mr. Frumusa's contention that he was authorized on the operating agreement to use the money to pay bills. And that's exactly what he did as managing member. If the jury rejected his, and by the way, you can see this throughout the entire trial. You can see it in the opening statement, closing remarks, his trial order of dismissal motion, cross-examination of Hernandez and Foster. That was his contention throughout the trial. If the jury were to have rejected his contention and concluded that, indeed, he was using the money for personal expenses.
This is where I'm getting confused, because it seems like relevant evidence, its tendency to produce or to support a material fact. Here we have a fact that there was a contempt order based on a series of facts where a civil court found that he had not complied with a directive of that court in its relationship with the, oh God, I'm drawing a blank, with the relationship, not with the court, but with the person who was appointed to the receiver. Thank you, Judge Wilson. And how do we move beyond intent there?
Well, I think you
See, it seems to me that you're rattling off the Molineux exceptions and then knocking them down one by one, but I'm saying assume it's not Molineux, it's just normal evidence.
Right. Well, the Molineux exceptions ultimately exist because they are relevant to, or they're germane to, any sort of relevancy analysis. So I think we should draw some guidance from Molineux here.
Okay.
I think it's appropriate. Now, I think your question suggests that you're pointing to the appellate division's decision in which the appellate division concluded that it was relevant to show that Mr. Frumusa had disobeyed a prior order of the court, and from that one can conclude that it's relevant to the question of intent. But I would submit that that order did not show that Mr. Frumusa had disobeyed a prior order of the court. It showed
I thought it was to show that he didn't intend to, that he intended to deprive the company or the receiver of that money permanently. I thought that was the purpose,
Yeah,
or at least one of the purposes.
The appellate division, that was the ultimate conclusion that the appellate division drew. But it drew it from first concluding that it was relevant to show that Mr. Frumusa had disobeyed a prior order of the court.
But is it enough if it's not the disobedience, if it is intended to show that intent to deprive?
I don't see how one can get to the question of intent unless we first conclude that it shows that Mr. Frumusa had disobeyed the order of the court. And that is really the logic of the appellate division's decision. And there are 4 reasons why it wasn't sufficiently probative to show that Mr. Frumusa disobeyed an order of court and thus ultimately intended to...
Well, it showed that he didn't give the money back.
It showed that the contempt order showed that an appellate division, or excuse me, a Supreme Court judge had concluded that Mr. Frumusa had not given the money back. And that's not an evidentiary fact, but rather just...
But he didn't, Mr. Frumusa didn't even challenge a contempt order. He challenges admissal at a criminal trial, but in the civil trial, he didn't even challenge it.
And I don't see how that would add to its relevance. If anything, it would show that the
Well,
determination...
you're using it, as I understand it, to establish certain facts. And if he didn't challenge those facts, then how would they not be admissible?
Well, if he
For
didn't-
relevance purposes.
Well, I think, ultimately, evidence is relevant where it has some probative worth. That
Sure.
goes without saying, obviously. And
The way I understand your argument, you're not saying that it's not probative. You're simply saying that it's prejudicial.
well, I'm saying if to the extent you were to conclude that there was any probative worth, what we're talking about is extremely remote probative worth. And I've set forth the reasons in my brief, but the first, as
So
I
let's
was
talk about
suggesting,
why
Judge,
isn't it just harmless under
why
the
is it- well,
circumstances? Just go.
First of all, I don't think it's amenable to harmless error analysis because it's hard to imagine that any evidence which essentially directs a verdict against a defendant could be more prejudicial.
But the prior orders are all in without objection, right, that he violated, directing him not to,
That's
right?
correct.
And there's also testimony that, from the receiver and from his co-owner, that he took the money and didn't return it.
That's correct. So what I would suggest is that shows why the contempt order had such little probative worth.
Was there-
Why doesn't it always-
That really rendered the contempt order unnecessary.
Why doesn't it also show that it's harmless, though?
Well,
There's so much other evidence that,
Well, I don't believe that the evidence is overwhelming. What we have here is an operating agreement that authorized Mr. Frumusa to manage the company by using company money. There was much to support Mr. Frumusa's contention.
But you agree, but you don't object to the other orders going in. It's only this contempt order, correct?
That's correct, and that order was different because of its finding that Mr. Frumusa had committed the very crime that he was charged and
counsel.
faced at trial. Thank you.
Ms. Walford? Ms. Walford, doesn't the admission and use of the court's judicial finding invade the province of the jury in this case?
No, not, Your Honor, in this case. What we have here is an order that was signed by a Supreme Court judge in a civil action against 3 companies that 2 of which contain the name of the defendant, but not the defendant himself. So it's very important that we talk a little bit about what that order actually did.
But you argued essentially, or you tried to argue that it was related to defendant himself.
Yes, but there's 2 parts to that, because it's what that order is a piece of the puzzle that the prosecutor had to put together to get to the point in time where we could prove that defendant, who was the majority owner in the corporation or in the company, did not have the right to take this $250,000.
But didn't the people argue that he failed to, as you say, he's in contempt, he failed to comply with
Yes.
that order, so the judge was trying to make him comply, he didn't, but now you can make him comply, right? You can now serve justice.
Yes.
I'm paraphrasing, but that's really what the people were arguing, correct?
Is exactly what the people argued, and I think that probably exceeded the appropriate argument on the use of that particular document, because it is somewhat of a safe streetsy type of argument that we probably should have
Well,
avoided.
then how can this be harmless error, given that argument?
Well, a few things. First of all, I want to clarify, there was no objection to that comment whatsoever, so that wasn't stricken, there was no discussion.
Was there any limiting instruction requested or sought on the order itself?
No, Your Honor, and I would like to point out that although we're here talking about this case as if it's a preserved issue, if I would direct the court back to when the order comes comes into evidence, because the people mark it as an exhibit and move it into evidence, and the words out of the defense attorney's mouth are, "No objection, Your Honor." Done. So to the extent that he disagreed with the Molineux ruling, which he never objected to the ultimate ruling of the court, he then, at the point in time when this order goes into evidence, says no objection, consenting to the order at that point coming into evidence. That's the only thing that the jury heard. And then there's no request for a limiting instruction. The people had, at the beginning of the case, very specifically said that we were putting it in to prove an intent to permanently deprive. That was part of our theory of the case, that we knew from statements that the defendant had made to the Rochester Business Journal that his defense was going to go down that line.
Isn't it relatively common in the criminal context to take civil orders and put them in to show relevant facts?
It can be.
All right, so give us some examples of when that would happen.
Well, there's times when we have family court orders that are.
So orders of protection, things like
correct.
that would come in.
And they're temporary orders sometimes, and sometimes they're permanent orders, but there are orders.
Ultimately, they make a finding to stay away, but that's not a determination as to the ultimate facts, but only as to relevant evidentiary facts in dispute.
Right, and here it's not the determination as to ultimate facts either, because it requires not only that the jury draw the lines that we requested, which was to take that order that was to defendant's 3 companies and use the other evidence that we presented to draw the conclusion that it was actually the defendant who stole the money, not the 3 companies taking the money and not paying it back, but that the defendant, by creating a new account outside of the receivership and having funds funneled into the account that only he had access to, that in fact, even though he was putting it in the name of his companies, that it was actually the defendant. Judge Fisher's order says nothing about that. So in order for the jury to get to the point in time where they can convict him of grand larceny as charged by the jury, by the judge in this case, they have to go far, far beyond the order of Judge Fisher. But there is, I think, ultimately a jurisdictional issue that I apologize that it's not raised in our brief, because we have a situation here where I would call it a motion in limine, even though it was titled the Molineux application, about this evidence prior to the beginning of trial. There is no objection to the court's ruling on that. There's no objection to the order coming in. There's no request for a limiting instruction, and there's no request for an instruction during the final jury charge. At that point in time, the defense has abandoned any effort at trying to fix this problem that they now bring before this court. And I think that affects the very jurisdiction of this court's ability to hear this, because the issue is entirely unpreserved. And I do apologize because that was not raised in our brief. But I do agree with the court that this is not Molineux evidence. This is evidence.
I was trying to think of how it got here, but then it came, an appellate division judge.
Yes,
Right.
and I can say that I know from reading the pleadings, the jurisdictional issue was not raised by us either at that stage. So I apologize to the court for that.
So in fairness, it was perfectly proper for the grant to be given then.
Yes, I don't fault the court at all for granting leave in this case. It is an unusual case. I can understand why he would grant leave in this case, and we did not raise a jurisdictional issue. But it really truly is not Molineux. It is about the crime that the defendant is being charged with. It is not an unrelated crime. There is no propensity issue here. This is about whether or not the defendant, as the majority owner of a company, had the right to keep the money. And defendant put that at issue himself. And this became far more relevant in this case because it actually was about the money that the defendant was accused of taking, and because the defendant's state of mind was put in issue by the way the defendant tried the case.
Thank you.
If there's no further questions, I'll rest on our brief.
Thank you, counsel.
Thank you.
Counsel?
Ms. Wolford is correct. The people did not raise in their brief the question of preservation, and I would submit there's good reason for that. The people sought to introduce this order in the context of a Molineux application. Defense counsel vigorously opposed that application. We have raised exact grounds that were addressed by the court below, raised before the court below. And to the extent defense counsel didn't object to the actual admission of the order in trial, well, an objection at that point would be futile. And as
I wasn't particularly moved by that part of it since it wasn't raised. The question of the limiting instruction, though, may be more relevant to your argument.
a limiting instruction is not a panacea to the admission of highly prejudicial evidence. We see that all the time where erroneous Molineux evidence is admitted, and despite a limiting instruction, I'm not sure how you could even draft a limiting instruction that could cure the
You mean it was a
prejudice.
strategic choice not to object? Or to
Clear-
request, excuse me, the
clear-
limiting
clearly
instruction?
Clearly not a strategic choice. Counsel did his best to minimize the damage. He dressed it, the contempt order made this argument about the varying burden of proof.
No, I'm saying that are you arguing it's a strategic choice not to request the limiting instruction?
I don't see it being a strategic choice. I don't see how you could even envision what sort of limiting instruction could be given to, what do you tell, ignore the elephant in the room? A judge, a Supreme Court justice has found that the defendant has committed the very crime he's...
The core of your argument, the way I understand it, is the contempt is actually a finding that the defendant stole the money. And that's why, and that's the core of your objection. But it seems that the core of the order is that the businesses failed to abide by the order to return money, which is different than saying that the defendant stole money. You want to address that?
Well, first of all, I think the term conversion is a fancy term for steal. I mean, you should expect jurors to give words that are used in the course of a trial the ordinary meaning.
Well, you see what I'm saying, though. He sets up 3 accounts. It's right before the receiver is appointed. It looks like he's planning to siphon off the money. He doesn't comply with the order to return the money. That's unquestioned. So by not complying with the order to return the money, that's not the same as saying he stole the money. That requires intent. Intent means they have to look into these facts then.
I understand the point you're trying to make, but I would suggest that common understanding of conversion is a theft. And
Do you
that
think the
jurors would
word
see that.
in the contempt order, conversion, is sufficient to
Well-
make it so prejudicial that it shouldn't be admitted?
Well, in conjunction with the language of the order, which says calculated to deprive WHD and impede the rights of WHD,
I see.
which refer.
I see.
And if I could
But that's
just-
the key language
if-
you want us to look at.
If I could just address the last part of your
ahead.
point, Judge Fahey, which I think is important here. The people still have not addressed why they didn't introduce the July 27th order itself. The July 27th order directed Mr. Frumusa to turn over this money. They could have introduced that order, and that order, in conjunction with the testimony of Hernandez and Foster, would have demonstrated that Mr. Frumusa had violated a prior order of the court. This is the order that was introduced, just a roundabout way of demonstrating the same point, but far more prejudicial.
Thank you, counsel.